All right, I'll look first to the court reporter. Are you ready for us to go back on the record?
Absolutely.
Great, thank you so much. I will orient us. Good afternoon. It is February 21st, 2025, and this is the afternoon portion of our hearing day. It is the first day of rebuttal, the rebuttal portion of the hearing on the proposed Sites Reservoir project. We'd heard from Ms. Bizzoni, who is the panel one witness for the Sites Project Authority this morning. We got through redirect, and we were going to see if there was any recross questions before we broke for lunch. Before I jump right into that, we did have a minor logistical issue that well, hopefully it's minor, that I did want to bring up with, I think it's um, the South Delta groups, which is we've been receiving kickbacks on email from the packbell.net email addresses. I believe there are two of them on our service list. And I wanted to let you know we had our DIT folks investigate this problem, and it's not on the state water boards. It's not directly on our end. Apparently it may be a spam filter problem, or also there is a more global issue, I think, supposedly between Microsoft applications and the Yahoo-based applications like packbell.net. So I wanted to bring it to your attention and ask, I mean, of course, we can substitute in another email address. It's not, I would imagine, there are a number of you on that
There's
service
two
list.
there's two folks on there. Yeah, that's
Yeah.
Mr. Dan Jr. and Dan Senior Nomalini, and that has happened in the past, and I don't know why
Okay.
they have Yahoo still, but I'll talk with them.
I just wanted to let you know that we are doing our best, but apparently it's with different powers over at Microsoft or Yahoo. I'm not sure.
All
Great.
right.
Well, thank you. So noted for that. With that, I think we can turn back to our witness, Ms. Bizzoni, and where I left off was looking to Mr. Schutz, I believe, to see if you had additional questions for Ms. Bizzoni. So I'll ask my team to go ahead and pin the appropriate parties, Ms. Chester, Ms. Bizzoni, and we will start with Mr. Schutz.
Okay, that's fine. I just had a couple of questions for Ms. Bizzoni regarding this supplemental testimony. Could we bring up the exhibit, and I don't recall which number it is.
I believe it's Sites 424. I think that
Correct.
will be, yeah.
And look at page 1, please. So, Ms. Bizzoni, did you have a hand in writing this letter, or is this just something you became aware of that's part of the position of the Sites Authority?
I was involved in drafting portions.
Okay, thank you. So if we scroll down to the sort of the middle of the first, keep going there. Do you see there where it says options 1 and 2 do not provide the science-based framework needed? Would you explain to us why options 1 in particular or 2 are not science-based?
Take each option one at a time.
Sure, option 1.
I believe that the concerns for each option are detailed as we move through the letter. So if we're going to take them individually, I think we should maybe move down to the top of page 2, where it discusses some of the concerns with option 1. And this highlighted sentence beginning at the end of the first line presents the concern that this appears to be a one-size-fits-all approach that could result in significant reductions in potential diversions without clear evidence of corresponding ecological benefits. And I do not have information beyond that statement.
Okay. Um, I understand the concern. What in your mind would constitute clear evidence of corresponding ecological benefits?
I am not a fisheries expert. I do not have an answer for that question.
Okay, very well. And do you have a response for option two?
Yes, if we could scroll down a bit more, we address the option two, the as noted here, the signatories to this letter believe that option two also overlooks unique characteristics of water supply projects and also ecosystem projects. This was a letter co-authored and co-signed by, I think, 6 different entities, and we discussed sites, reservoir, groundwater recharge projects, and floodplain restoration initiatives, all of which have potential ecosystem benefits that should be considered.
But that doesn't really get to the question of whether or not the proposed limitations are science-based, does it?
Objection, argumentative.
Can you rephrase the question, Mr. Schutz?
Can you tell us in what way the response here, which goes primarily to the benefits of sites, reservoir, and other projects, answers or supports the contention that the regulatory pathway for the Bay Delta Plan is not science-based?
I think that there would be a need to ask that question possibly with people with more fisheries experience or background, but I think that overall the issue that was being brought here is that there are projects that bring other benefits to the table. And if we do a 55% blanket percentage, as noted in this last highlighted sentence, that it may reduce the effectiveness of those other projects, and that this should be looked at holistically to see if there are other opportunities beyond flow specific actions.
Okay, I think we'll move on. Thank you. Looking at the top of this page, something that's right there, that's fine, yes. Something that's more in your area of expertise. Do you agree with the analysis or the statement here that implementation of the option 1, 42,800 CFS flow requirement for net delta outflow would reduce the yield to sites reservoir up to 30%?
Yes, I mentioned this in response to a question from Mr. Busher. This was a high level sensitivity or initial analysis prepared, I guess, by Mr. Walker. And although I don't know all of the details, we noted that it could be up to 30% for sites reservoir.
Okay, so you have some knowledge of that figure.
Yes.
Thank you. Okay, and then if we'd scroll down to the last page, please. And looking at the paragraph that talks about importance of policy alignment.
Oh, I think that's up a little bit towards the bottom.
I'm sorry, that's on page 3. I didn't realize there was a 4th page. My bad.
Scroll up just a little bit more.
There you are.
There we are. Thank you.
Right there, that highlighted section right there. Isn't the update of the Bay Delta Plan also in significant part a policy initiative?
Objection calls for a legal conclusion.
I don't know that policy is a legal category.
Well, where are we?
Uh,
Let me stop you there. Mr. Schutz, why is this important? How Ms. Bizzoni characterizes the State Water Board's Bay Delta
We're
Plan
talking
update
here
effort?
about alignments with policy, with state policy, and the question goes to whether there are other policies that might conflict with some of these policies in some form or another, and whether it's a question of aligning with policy or aligning with policies that the site's authorities and others happens to agree with.
Well, let me ask for Ms. Bizzoni, did you participate in the drafting of this portion of the comment letter?
I am sure I read it, but no, I would not say in any significant context. I would have read it as part of the overall letter, but not drafted this.
And do you have any opinion about whether options 1 and 2 run counter to the listed efforts there by the State Water Board?
Yes, I think that they could, and I believe that that's the overall context that this entire letter is pointing out. I do think that this paragraph is to drive importance of policy alignment, meaning all policies, including the water quality control plan update, that this current draft of a policy appears to be misaligned with other existing policies.
Thank you. And I think I just misspoke. I described these as State Water Board. Those that are listed are not necessarily State Water Board initiatives. Thank you. I think that establishes somewhat of a foundation for your question, Mr. Schutz. So I'm going to hand it back to you.
Thank you very much. Is it your opinion that options 1 and 2 are consistent with the update of the Bay Delta Plan?
I'm not sure what your question means. They are part of an option within the draft update.
And do they align with the policies that are embodied in the draft update? I don't have an opinion on that. I have had a very limited review of the overall update, really focused in on these options. I would assume they align with the overall update, but I don't have a real opinion. Thank you very much. I'll turn it over to Mr. Busher. Thank you.
Thank you, Mr. Schutz. Mr. Busher, if you have additional questions, please go ahead.
Excuse me. Yeah, just a few. If we could scroll back up to the analysis of options 1 and 2, Ms. Bizzoni, did you draft either of those 2 responses in any meaningful way, like differently than you described the other paragraph?
I did not do the initial drafting, but I remember providing comments and suggested revisions. So I had more input to this portion.
Okay. And was there I don't know, fisheries expert, as you use the term, who was involved in drafting the responses from
I
the
do not
site's
know.
authority?
Oh, I'm sorry, I didn't mean to cut you off.
Sorry, just from the site's authority.
I don't know.
Okay. we could scroll down to the signature blocks here. Are any of the other signatories participants in the project?
Can
There's
you
two
scroll
more on the
down
page.
just a little bit more? Member districts within the Tehama-Calusa Canal Authority are Reclamation District 108 and Dunnigan Water District. However, they also have interest in the other projects that were identified in the bullets on page 2, I believe.
Okay, great. And that was going to be my next question. If we could go back up to the bullet points for page 2, option 2. The second and third bullet points here are not really relevant for the site's authority or the site's reservoir. Is that correct?
Correct. Those are geared towards other signatories.
Okay. To your knowledge, has there been any follow-up of what you described as the high-level sensitivity analysis performed by Mr. Walker after the initial determination that it could reduce diversions by up to 30%?
No.
Earlier today, you talked to Mr. Schutz about the 2017 draft scientific basis report as distinct from the 2023 staff report. Do you think that the 2017 scientific basis report provides a balanced scientific-based framework?
Objection, it's outside of the scope of redirect.
It's not. She highlighted and referred to the section on page 1 of the letter that says alternative 6A does not provide a balanced science-based framework. I want to know whether the 2017 scientific basis analysis that is underlies that is a balanced scientific framework.
Thank you. I'm going to allow the question. It may not be within the scope, but given that this is the first time we've seen this document, I mean, the document kind of opens another door. So I'll allow the question. Go ahead, Ms. Bizzoni.
I might have misspoke earlier, but I believe the VAs were presented in the scientific basis. Oh gosh, scientific basis report supplement in support of the voluntary agreements, which I believe is a different document than the 2017 scientific basis report that you are referring to.
So fair enough, and I think that is correct. Are you familiar generally with the 2017 scientific basis report?
I probably read it a number of years ago. I have not recently looked at that document.
Well, so fair enough. And let me ask this a little bit different way because I don't have, questions about the substance of that document. In the process of updating the Bay Delta Plan, are you familiar that the Water Board published a scientific basis report around 2017?
Yes, I am. Oh, sorry.
Yeah, go ahead.
I am aware that that document exists.
Okay. And do you think that that document is a balanced science-based framework for the updates to the Bay Delta Plan?
I do not have an opinion on that.
Okay. And then I think the last couple questions here at the end of the, excuse me, first highlighted section on this page, you indicate that it would be without clear evidence of corresponding ecological benefits. Do you see that?
Yes, I see that sentence, or in the sentence.
And do you agree that positive population growth of endangered species is an ecological benefit?
Objection, it's outside the scope of Ms. Bizzoni's rebuttal as well as her redirect.
I think that's right, Mr. Busher. I mean, I don't want to.
Well, so I mean, I guess what I would say is option one, the science-based portion of that comes from the 2017 report, and I'm happy to put that on the screen and look at it. The flows, delta outflows of 42,800 CFS cause intergenerational increases in populations of longfin smelt. Flows
Mr.
below that
Busher,
cause,
hold on.
and so I think that's within the scope of the letter.
Ms. Bizzoni's testimony, I mean, I also wonder the probative value of this. Ms. Bizzoni has stated several times that she's not a fisheries expert. And that's not the basis of any of, as I understood, of her opinions that she's expressing. So I don't see the probative value of getting into this question of Ms. Bizzoni's opinion about fisheries impacts, unless that's not where you're going.
But I don't think it is a question about the fisheries impacts. I just want to know, right? Well, let me try this
Okay.
way, see if this is a fair way. Can you describe what the corresponding ecological benefits are that are referred to in this letter?
I cannot. I can talk to really the first portion of the sentence prior to without. That is within my area of understanding.
And do you have an understanding of who within the site's authority would be the person to speak to what it means to be without clear evidence of corresponding ecological benefits?
I would say there's a number of people involved. Am I really supposed to provide names? I think that others like Ms. Forsythe and those from the ICF team who have some testified through this proceeding have much greater understanding of the ecological benefits.
And you have no opinion as to whether positive population growth of endangered species would qualify as an ecological benefit or not.
Objection, asked and answered.
I don't think it was ever answered.
It was not answered, so
Well, asked already and objected to.
that's fair. Let's move on, Mr. Busher.
I got no further questions.
Thank you. Mr. Reese, I believe you are up next if you have additional questions for Ms. Bizzoni.
I do not.
Thank you. And then finally, Mr. King, do you have any additional questions?
I do not. Thank you.
Thank you. And I believe with that, we have completed this first panel with Ms. Bizzoni, and we can move on to the second panel, which also includes Ms. Bizzoni and, as I understand, Ms. Forsythe. And Ms. Chester, will you also be with this panel, or should I look to someone, a colleague?
This is also me. Thank you.
Okay, thank you. And
Ms.
I will,
Kennedy, this is
yeah.
Aaron Ferguson. I wanted to make one announcement with respect to panel 3. If we get there today, only Mr. Navarro and Mr. Kundi are available this afternoon, and they're prepared to go if we get to that point. But Mr. Charter will not be available till Monday morning. I just want to make you aware that that's
Thank
who we
you.
have available. And that's
Understood. And I think probably that will work out fine, because we could, if we get that far, we can hear the summary of direct testimony from the other two and then see where we are. So,
okay, great.
for that. Mr. Reese.
But yeah, related to that, maybe we could just do a reassessment of how long we think this panel is going to take. And I forgot what people have for cross and set, et cetera, in front of me.
Yes. Let's start with I guess, Mr. Busher, do you have an
Yeah,
estimate?
I'm gonna go first on this one. I think I probably have an hour,
Okay.
a little more. I don't know.
And Mr. Schutz, will you also have questions for this panel?
I do, and depending on how much Mr. Busher covers the area that I was planning to cover, I might have an hour as well.
Okay, so it sounds like Mr. Reese has a significant amount of time before we get to you.
Thank you.
Thank you. Mr. King, had you indicated that you will not be available on Monday? Am I remembering that correctly?
Monday afternoon, I have a 1 o'clock, I believe. That shouldn't be too long.
But you'll be here in the morning. I just wanted to make sure you had an opportunity to ask questions of this panel, so.
Yeah, no, I appreciate that. No, I'll be available in the morning, yes.
Okay, thank you. With that, I will welcome back Ms. Forsyth. I will go ahead, and I know you've been with us before and we've
Have you made a decision about the scope of scope of the rebuttal?
Yes, and you are right to interrupt me, and we should get to that. So let's, before I swear you in, Ms. Forsyth, let's talk about that. So I had a chance over the break to go back and look at my evidentiary ruling and Mr. King's testimony that was referenced by Ms. Forsyth in her testimony. And based on the written testimony that I ruled would be excluded from the evidentiary record, it looks to me that Ms. Forsyth's written testimony cites to portions of Mr. King's oral testimony that is essentially verbatim from the stricken portions of the written testimony. So, and excuse me while I flip, I'm trying to get to the correct pages here. It would be my understanding that to the extent Ms. Forsyth, and I wanted to talk to you, Ms. Chester, to the extent Ms. Forsyth's testimony is in response to portions of Mr. King's oral testimony that is stricken, that you may be willing to withdraw the testimony. That said, I did want to remind all of us, and Mr. King too, that the underlying, to some extent, I struck the testimony because the primary documents were admitted into the evidentiary record, and the primary documents served as, I mean, they speak for themselves. Those aren't cited in Ms. Forsyth's testimony, but I just wanted to reiterate that those are in, so it's the kind of general subject matter of some of the testimony is still included. And with that, I wanted to turn to you, Ms. Chester, if you have given that clarification on the stricken testimony, if you have a response or additional thoughts about that.
Yes, to the extent that Ms. Forsyth's testimony specifically addresses the stricken portions, we would offer to submit a corrected version of the rebuttal testimony that eliminates paragraphs 5 through 10. But we would maintain paragraph 11, which includes proposed conditions, which may address those underlying topics that remain in the proceeding.
Okay. Thank you. That is extremely helpful. With that, Mr. King, did you follow along that it sounds like the authority will submit revised testimony that strikes paragraphs 5, 6, 7, 8, 9, and 10, but includes paragraph 11. So you may want to cross-examine with respect to paragraph 11.
11 on, right? Or is 11 just by itself until the end?
I think that's the end that responds to your case in chief.
Okay. Okay. I don't know if it's going to be applicable now, but I just had a question regarding the site visit videos. My understanding is that there's not a transcript for that. So so would it be helpful? I'll have to go revisit it, but if it would be helpful for me to identify those videos, if I'm going to use it for cross when my turn comes.
Yes, it may be best if you want to, I'm not sure the best way to handle that, because it doesn't make sense for us to attempt, we'd probably break our internet connection if we tried to play the videos. It would be helpful, I think, to identify those
In advance.
in advance. I don't know, Ms. Chester, do you have any thoughts on this challenge?
Not on how to resolve it, but certainly if Ms. Forsyth is being questioned about actions or statements made in the video, we would want the opportunity to confirm they're correct or as characterized by Mr. King.
Yeah, that seems fair enough. So here's what we may do. As we get through this panel, I may ask you, Mr. King, to, if it's, well, I guess I get to decide. I may suggest that you put in front of Mr. Reese and that we get started on your cross so that way if we have any challenges that need to be addressed, kind of, hopefully not too late on a Friday or over the weekend, but that we can have a little time to do that. And then when we reconvene on Monday, we could finish with Mr. King's cross. That's the best I can come up with on the fly.
At this point, looking through it, I don't know if I'm gonna actually, I thought my video would be relevant to 5 to 10, so I'll have to revisit. But at this point, I don't think we're gonna have that issue. But I just wanted to bring it up. Thank you.
Great, thank you, Mr. King, and thank you, Ms. Chester, for helping me think that through. Mr. Busher.
Yeah, thank you. I was just going to ask that if those paragraphs get removed, we do it in a way that does not change the rest of the paragraph numbers, because I got a bunch of paragraph number specific questions I was going to ask, just so the record's clean.
We'll submit a red line so that it does not change the paragraph numbering.
Thank you very much. I appreciate that.
And thank you both. Are there any other issues before we get started with this panel? All right, then with that, welcome back, Ms. Forsyth. If you would please come off mute and raise your right hand. Ms. Forsyth, do you swear or affirm under the penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much, and please proceed, Ms. Chester.
Thank you. Just for clarification again, the purpose of this panel is to address the rebuttal testimony regarding exchanges and exports. As stated, there are 2 witnesses on this panel, and as noted, Ms. Bizzoni was on panel 1. Again, her panel 2 summary will only address the topics applicable to panel 2, but I'll turn now to Ms. Forsyth. Ms. Forsyth, can you please state your full name for the record?
Alicia Forsyth.
Do you understand that you're presenting your testimony under oath?
I do.
Is Exhibit Cites 410 an accurate statement of your written testimony for this rebuttal portion of the proceeding?
It is.
Did you prepare that written testimony?
I did.
Does your written testimony cite other exhibits that were submitted as part of the rebuttal portion of this proceeding?
It does. It cites Cites 411 through Cites 413.
And did you confirm that the exhibits submitted as Cites 411 through 413 are true and correct copies of the documents referenced in your written testimony?
I did.
Is your firsthand knowledge of each of these exhibits reflected in your written testimony, Cites 410?
It is, yes.
And is Exhibit Cites 414 an accurate summary presentation of your written testimony?
It is, yes.
And did you prepare that summary presentation?
I did.
At this time, would you please summarize your testimony for this portion as set forth in Cites 414?
I will, thank you. Ms. Mullins, if you could bring up 414. Thank you. All right, thank you, Ms. Chester. Thank you, Hearing Officer Kinsey and members of the State Water Board. I appreciate the opportunity to provide rebuttal testimony in support of the authority's water right application today. Next slide. My testimony is offered in rebuttal to 2 specific items. The first is the potential for impacts to downstream property rights and water right holders in the Colusa Basin drain. And the second is the potential for anadromous fish benefits resulting from the Bureau of Reclamation's use of Cites project water and or from exchanges. I'll address these 2 items in this order, but I do think I will in light of what was just the proceeding that just happened here, I think we skip the next couple of slides.
Yes, please skip ahead of any specific that relate to paragraphs 5 through 10, and we will also submit a revised version of the summary if helpful.
Thank you. So Ms. Mullen, if you can skip to slide 7, please. This slide and the next one identify the additional 4 proposed water right terms that the authority has submitted, recognizing the authority's commitment in the Maxwell Irrigation District Agreement to development of a creek operation plan and its value of trust and integrity with respect to the local communities in its strategic plan. The authority has proposed 4 additional terms and conditions to be included in its anticipated water right permit for the project. The first of these would be a term relative to private property rights. This term clarifies that the authority is to obtain the necessary legal rights for the project. The second term identifies the specific diversion criteria for the project's diversions to storage from Funks and Stone Corral creeks. This term clarifies the conditions under which the authority may divert water to storage from these creeks. Next slide. The third term adds consideration of downstream water right holders to the previously proposed creeks operations plan. This term establishes a collaborative process to ensure these downstream water right holders are also considered in the development of the plan, and also ensures that these water right holders can participate in the development of the plan. And then lastly, the fourth term requires the authority to publish specific data on the creeks on its website on a daily basis. Recognizing that understanding what is happening on the ground is critical for downstream water right holders, this term provides transparency in the authority's daily operations. Next slide. I will now provide an overview of the potential for anadromous fish benefits resulting from reclamation's use of sites project water and/or from exchanges. Next slide. The California Sport Fishing Protection Alliance asserts that the State Water Board cannot rely on the anadromous fish benefits of the project because there's no agreement with reclamation and no accountability or enforceability of those benefits. However, reclamation has identified these benefits in its final feasibility report for the project and in its final EIS, both of which provide evidence that reclamation is likely to implement actions to benefit anadromous fish. Next slide. There are 2 ways that anadromous fish benefits can result from the sites project. The first is reclamation utilizing water from its 16% storage allocation or sub-account, as sometimes referred to in the context of the modeling. This is reclamation simply utilizing its participation in sites reservoir to achieve these benefits. The second way to achieve anadromous fish benefits is exchanges between the authority and reclamation. It's important to note that reclamation's participation in the sites project will be memorialized in the partnership agreement between reclamation and the authority. However, the partnership agreement will not bind or control reclamation's use of its storage allocation, other than to require that that use be consistent with the authority's permits and approvals. Thus, the execution of the partnership agreement is really irrelevant to determining water right permit terms and conditions. The sites project operations plan is also irrelevant to this discussion, as that document establishes the procedures to be used in managing the water operations of the project, consistent with agreements and approvals, including that partnership agreement. Next slide. Relevant to this discussion is that reclamation must comply with federal law in the development and implementation of the partnership agreement, including the Water Infrastructure Investments for the Nation Act, or WIN Act, along with federal environmental laws such as NEPA. With regard to the WIN Act, the Secretary of the Interior is required to make several determinations relative to the Secretary's participation in the sites project. The Secretary is then required to notify Congress of these determinations. For the sites project, the Secretary found that the project would provide anadromous fish benefits and described those benefits, including the modeling to support those benefits, along with quantification of those benefits in its federal feasibility report. The Secretary's determination of those benefits was submitted to Congress with the project's final feasibility report in December of 2020. This determination provides evidence that reclamation is likely to implement anadromous fish benefits with its participation in the site's reservoir project. Next slide. The WIN Act requires that the Secretary comply with all applicable environmental laws, including NEPA, with participation in a state-led WIN Act project like Sites Reservoir. Reclamation completed a final environmental impact statement as a joint document with the site's authority, with the site's authority's final environmental impact report. That joint final EIS identifies increased CVP operational flexibility, which includes anadromous fish benefits as one of the NEPA project purposes, and the modeling conducted for alternative 3, reclamation and the authority's preferred project, included anadromous fish benefits through both reclamation's participation in the site's project and through exchanges with the authority. The final EIR also provides evidence that reclamation is likely to implement these anadromous fish benefits. Next slide. Or actually, yeah, I think next slide. And this concludes the summary of my rebuttal testimony.
Thank you, Ms. Forsyth. And then Ms. Chester, is my understanding, there we go, that Ms. Bozzoni then will provide a summary of this portion of her written testimony, rebuttal testimony. Is that right?
That's correct. For her direct examination, we don't plan to repeat all of the questions you previously heard in regards to direct on panel 1. We can assume that her answers apply to this panel as well. So skipping ahead a little bit, Ms. Bozzoni, is exhibit sites 395, paragraphs 28 through 53, an accurate statement of your written testimony for this rebuttal portion of the proceeding?
Yes, it is.
And do you have any corrections to your testimony?
Yes, I have 2. The first is that I would note my testimony includes a citation to exhibit sites 403, the programmatic biological opinion for the long-term operations of the CVP and SWP. This is a duplicate of a previously submitted exhibit sites 203. Also, in reviewing my written testimony, I noticed that the content of a few footnotes were inadvertently combined. This affects footnotes 16, 18, and 20. We will submit a corrected version to clarify the content of those footnotes, including corrected website links for reference by others. This change or combination of these footnotes does not change how I relied upon the information or any of my conclusions.
Thank you. And what additional exhibits were submitted in support of this rebuttal portion of your testimony?
Sites 396 through sites 405.
And did you confirm that the exhibits submitted are true and correct copies of the documents referenced in your written testimony?
Yes, I did.
Is your firsthand knowledge of each of these exhibits reflected in your written testimony?
Yes, it is.
And at this time, would you please summarize your testimony submitted for this portion of the proceeding as set forth in sites 406?
Yes. And Ms. Mullen, if you could open sites 406 and start at slide 19, please. Thank you. For this panel, I will present testimony regarding exchanges and Delta exports. Next slide. The exchange topics I will cover address items raised by CSPA and will include an overview of exchanges involving Sites Reservoir, proposed permit term for exchanges, and a discussion focused on exchanges between Sites Reservoir and Shasta Reservoir. Next slide. Mr. Schutz presented testimony that the environmental benefits associated with sites exchange operations may not occur. specifically stating that the exchange proposed with Shasta could not be relied upon to benefit Sacramento River anadromous fish, and that there is a lack of mechanisms to manage and enforce exchanges to benefit the fisheries. Next slide. The purpose of exchanges between the sites project and the CVP and/or SWP is to assist in achieving the objectives of all three projects in an environmentally beneficial or neutral manner. Exchanges can help sites meet objectives by providing increased flexibility and capacity to deliver water, and it may assist the CVP and SWP in meeting regulatory obligations and their authorized purposes. Next slide. Exchanges are primarily proposed in April through June during drier years when the delta is in a balanced condition. This slide shows an example of an exchange operation where water is released from Sites Reservoir, which allows for an equal amount of water to be held in Shasta. This figure represents a month-long exchange example. So flow rates in cubic feet per second are the monthly average. This is only illustrating one potential exchange operation. The left half of the figure shows operations without Sites Reservoir. In this example, there is an average release of 8,600 CFS at Keswick, which results in Shasta end-of-month storage of 1.977 million acre-feet. Downstream, the Sacramento River below Freeport is 6,800 CFS, and delta outflow is 5,000 CFS. The right side of the figure shows operations with an exchange between Sites Reservoir and Shasta. In this example, Sites Reservoir releases 1,000 CFS for the month, resulting in a decrease of 61,000 acre-feet within Sites Reservoir. Shasta is able to reduce its releases at Keswick by an equivalent amount so that those releases are now 7,600 CFS, and this results in the month-end storage being at 2.038 million acre-feet. Looking downstream, the flow below Freeport remains the same at 6,800 CFS, and delta outflow and exports also remain unchanged. This figure provides an example operation that allows for an additional 61,000 acre-feet in Shasta for use for cold water pool management. Next slide. As mentioned, exchange operations, such as in the example I described, would be undertaken with neutral or beneficial CVP or SWP operations. This means that exchanges cannot affect the project's ability to meet applicable laws, regulations, BIOPs and ITPs, and court orders. With this in mind, the Sites Authority has proposed a term that would require this to be true for an exchange to be conducted. The exact language of the proposed term is included in my written testimony on page 15. Next slide. Mr. Schutz states that the management of Shasta Reservoir is entirely at Reclamation's discretion and that exchanges with Sites Reservoir could not be relied upon to benefit anadromous fish in the Sacramento River. However, this does not acknowledge that Water Right Orders 90-5 and 91-1 require Reclamation to manage temperature in the upper Sacramento River. This is done through the development of a temperature management plan, which considers effects on fish populations, management of storage and cooled water pool, and downstream demands. Next slide. The development of past temperature management plans through collaboration with the Sacramento River Temperature Task Group have resulted in Reclamation and others taking action to improve temperature management for the benefit of fisheries. Actions during drought years have included requests and agreements with the Sacramento River settlement contractors to delay spring diversions, encouraging participation in water transfers, and reclamation bypassing hydropower production. These actions were undertaken to maintain more water in storage during the spring to preserve the cold water pool early in the temperature management season. Next slide. Reclamation's past practices indicate that Reclamation takes temperature management obligations seriously, and that the anticipated exchanges with sites would provide an additional tool for Reclamation to satisfy its temperature management obligations. And that concludes my exchange section. Next slide, please. I will now talk about export of sites water at the South Delta export facilities. Next slide. The export topics I will cover address items raised by Mr. Wilson and will include rediversion of sites water at South Delta export facilities, temporary urgency change operations, and delivered to sites water to lands within the South of Delta place of use. Next slide. In his testimony, Mr. Wilson proposed a term which is similar to a term included in previous and recent water transfer orders. However, the version of the term Mr. Wilson proposes says that rediversion of water released from sites reservoir at the South Delta export facilities should meet the requirements of Joint Point of Diversion, or JPOD, Stage 3. He states that the action proposed in the sites application is most similar to this stage of JPOD. Next slide. DWR and Reclamation have existing regulatory approval to move transfer water through Banks Pumping Plant and Jones Pumping Plant, which will also be used to redivert water released from sites reservoir. Export of transfer water, or in this case, water released from sites, does not allow DWR or Reclamation to violate conditions imposed by regulatory agencies. Next slide. The version of the term that is included in transfer orders does not specify a JPOD stage, but rather requires compliance with the various plans required under Decision 1641 for use of JPOD. Each stage of JPOD allows for different actions. Specifically, JPOD Stage 3 operations allow for DWR and Reclamation to divert at the full capacity of the export facilities. However, DWR's permits do not allow for full use of the physical capacity of Banks Pumping Plant. Rediversion of water released from sites reservoir will not create JPOD Stage 3 operations, because these operations are triggered at pumping levels greater than that authorized during the transfer window when sites water would be exported. Next slide. In addition, DWR and Reclamation have limitations specified in the BIOP and ITP issued for long-term operations of the CVP and SWP. These annual limitations are summarized in the table on the right. Exports of sites water would also be subject to these limits. Next slide. Considering these existing regulatory conditions, this table shows the average percent increase in South Delta export facilities during July through November due to sites project operations. The effects associated with this level of additional export were evaluated in the final EIR/EIS. Next slide. A permit term should be included to formalize that rediversion of sites water would be subject to existing regulations that apply to DWR and Reclamation's operations. We have proposed a term that is consistent with that included in recent water transfer orders. The exact language of the proposed term is included in my written testimony on page 21. Next slide. Mr. Wilson also proposed a term that would preclude rediversion of water released from sites reservoir at the South Delta export facilities during times when there is a TUC order allowing for relaxation of any Decision 1641 objectives. Next slide. Any such TUCP would be filed by DWR and/or Reclamation. A TUCP is typically submitted early in the water year. prior to when water supply conditions and the potential need for water transfers are fully understood. Because of this, orders issued pursuant to TUCPs require evaluation and analysis prior to moving any transfer water when the TUC order is in effect. This is not mentioned in Mr. Wilson's testimony. He also presented no analysis or evidence that rediversion of site's project water would exacerbate water quality conditions when the TUC order is in effect. Next slide. To maximize the potential water supply benefits of site's reservoir, decisions regarding water use during drought conditions should be made in real time to allow for management of reduced water supplies. The site's project will deliver water to storage partners during the types of droughts that have necessitated TUC orders in the past. Next slide. Decisions regarding the movement of water during drought are best made within the existing process that considers conditions at the time to balance beneficial uses during a drought. A blanket prohibition, as requested by Mr. Wilson, would reduce the operational flexibility and critical water supply the site's project is intended to provide. Next slide. Finally, Mr. Wilson suggests that the place of use be amended to eliminate the areas of the CVP that drain to the San Joaquin River because runoff from these lands historically contributed to increased salinity in the San Joaquin River. There's not evidence presented that delivery of sites water to these lands would increase salinity in the San Joaquin River, and it does not consider that irrigation districts within this area actively manage drainage to limit outflow through the use of sumps and wetlands. Also, water released from sites reservoir that could be delivered to lands within the CVP would be delivered during drier water year types when there is capacity at the Delta export facilities. The delivery of sites water is unlikely to result in increased return flow to the San Joaquin River because it is more likely that it would replace groundwater pumping such that the amount of applied water would remain the same. And that concludes the summary, my summary presentation of my rebuttal testimony.
Thank you, Ms. Bozzoni. I believe I recall that Mr. Busher, you were going to take the lead with questions for this panel. Is that right?
That's correct.
Please, if you have questions for this panel, please go ahead.
Thank you. Thank you again for your time, Ms. Forsyth. Good to see you again. I want to start. I think these are questions for you, Ms. Forsyth, but they're not necessarily specific to either report. I just want to make sure that I'm understanding and we're all on the same page with some nomenclature here. Reclamation is going to have storage, right, a storage allocation within the reservoir. And it could release water from sites instead of releasing water from Shasta with its own Bureau of Reclamation storage allocation. Do you view that as an exchange?
We do not view that as an exchange. However, I will say that at times our EIR kind of mixed some of these concepts. And since that time, we've really realized that and tried to be very careful on our language that that is not an exchange. That is simply reclamation utilizing its water stored in sites reservoir.
Okay. And so the exchange only occurs when reclamation is utilizing a different storage partner's allocation within sites reservoir.
Exactly.
Thank you. That's very helpful. I just wanted to make sure as we waded into this, I knew what I was asking at least. And is it the authority's position that the benefits to anadromous fish come both from the exchanges and the reclamation's own decisions about where it's releasing water from?
Yes.
Okay. Are there rules for reclamation's release of its own storage water in sites reservoir that are different from any of the other storage partners?
for those releases. I will say that the authority would like envision within our partnership agreement with Reclamation. I will say what sets Reclamation a little bit different from the other storage partners is that Reclamation must comply with federal law. And in compliance with federal law, it has to make sure that it is in compliance with things like NEPA and ESA, and that its actions have the appropriate NEPA and ESA coverage.
Okay, and so I take that point that Reclamation's internal decisions about when it can release water from Site's reservoir may be different than other storage partners' internal decisions. From the authority's perspective, is there any different? Right? If Reclamation comes and says, we want you to release some of our water, right? Do you evaluate that request and comply with it in the same way that you evaluate and comply with all the other storage partners?
I'm envisioning that, yes, we would, is if we can legally do it under our permits and agreements and obligations, then yes, I'm envisioning that we would, yeah.
The partnership agreement that you referred to in your testimony, is that designed to govern exchanges only, or exchanges plus reclamation, the reclamation swaps?
The partnership agreement is intended to govern Reclamation's participation in Site's reservoir, so the 16% as Reclamation has envisioned. And as of right now, we do believe that the partnership agreement will also cover exchanges.
And I took your testimony in your summary that the partnership agreement that governs both the storage allocation and, at least as of now, possibly the exchanges, is not going to bind Reclamation to any specific uses of its storage allocation.
That is correct, just as our benefits and obligations contract will not bind any other participants to a specific use.
Okay, so zooming out a little bit, is it fair to say that your response to Mr. Schutz or your rebuttal testimony is you don't take issue with his conclusion that there's nothing contractually binding or enforceable about Reclamation's use of water? You just think Reclamation will use the water in the way that you and they are envisioning based on the other information that you've described and presented?
There's nothing that we are envisioning contractually enforceable between the authority and Reclamation on its use of water. However, Reclamation does have to comply with federal law.
Certainly. But your contention is that it is likely, or the authority believes it is likely, that Reclamation will act in the manner it described, right, in the WIN Act approval, in the NEPA documentation, the other things that you pointed to. Not that they are required to in any sense.
Fair assumption to say that Reclamation will act in the manner that they have identified in the NEPA documents, and that they will have NEPA and ESA, federal ESA coverage for.
Okay. And when you say that Reclamation must comply with federal law, does that include the existing biological opinions in your mind?
I would say yes.
And does that include the required temperature management plans for Shasta Reservoir?
I would say yes.
Do you think it includes the record of decision for long-term operations of the Central Valley Project?
would say yes.
And reclamation has to do that whether the site's reservoir is constructed or not, correct?
Yes.
We could have Ms. Forsythe's testimony on the screen. What is this? I don't have the number in front of me. I apologize.
It's 410.
Thank you. And if we go to page 9 of the PDF, please. In paragraph 16A at line 18, refers to at the beginning of that line, the federal benefits of the federal government's involvement. Do you see that?
Yes.
And are those the benefits that are described in the letter that was submitted to Congress that's referred to in your testimony?
I would say yes. However, the federal feasibility report that was attached to that letter identified and quantified all of the benefits of the project, anadromous fish benefits, recreation, flood, CVP OpFlex, reclamation meeting its other environmental obligations. It quantified all of those benefits and then allocated which benefits reclamation felt were federal benefits that would be paid, I don't want to say paid for, but that would accrue because of that federal investment in the project. The secretary's letter to Congress identifies all of those benefits broadly. It doesn't specify in the letter which ones are federal benefits and which ones say are benefits under Prop 1, that the state is identifying as benefits funded in that way. That distinction comes in the attached feasibility report.
Can we look at the feasibility report sites exhibit 413, please? And if we could go to PDF page 22, Ms. Forsythe, this is part of the executive summary of the document. There's a section here that describes the final primary objectives, and then on the following page, I believe it's the secondary objectives of the project. Do these objectives encompass the federal benefits as you understand them?
They do, but they also encompass the state benefits and benefits that the federal government is not paying for. So these are functionally all of the benefits of the project identified by reclamation in the feasibility report. The allocation of who is paying for what benefit and thus what are the federal benefits come into play in some of the tables further down in the executive summary. So like,
okay, well, let me
okay.
let me try it this way, because I think I appreciate the clarification and I hadn't thought about it in that level of nuance. these objectives encompass the benefits that the project may provide according to the Secretary of the Interior. Some of those may be federal benefits, accrue to the federal government, provide a rationale for federal government funding. Some of those may be state benefits paid for by state funding, but the benefits are encompassed within the objectives. Is that fair?
Yes, that's fair.
Okay, thank you. The first benefit here is water supply, correct?
Yes.
And that is, and then the next two, CVP operational flexibility and anadromous fish. Can you explain the difference between the expected benefits in those categories?
The difference between the expected benefits in these two categories is that when reclamation quantified the anadromous fish benefit, they looked at the potential to increase cold water pool storage in Shasta and better manage water temperatures in the upper Sacramento River system for the benefit of anadromous fish. And that was quantified as a benefit, and then that same water is used for downstream purposes. That water could then, once it's served its cold water pool habitat in the upper Sacramento River system, that water has the ability and does continue down the Sacramento River, could either contribute to reclamation's in Delta obligations, or could actually be exported south of Delta and become CVP supply for south of Delta users. And so anadromous fish was kind of quantified as its own category. The CVP OpFlex included all of that potential to meet reclamation's environmental obligations and its contractual obligations, potentially with the anadromous fish water once it met its anadromous fish benefits, and with other water that was just released out of sites as a result of its participation in sites. So I'll say that some of the anadromous fish water contributes to the CVP OpFlex benefit also. It's doing double duty.
Okay, so the operational flexibility benefit is primarily then an additional water supply benefit, correct?
That's a fair characterization, yes.
And the anadromous fish benefit comes from some increase in cold water pool in Shasta at certain times, correct?
That was, yes, that is correct in how it was quantified in the federal feasibility report, yes.
Okay, thank you. If we could come back to Ms. Forsyth's testimony. Well, actually, let me ask one other question in this regard. The feasibility report happened or was published at the time when the 2019 biological opinions were in effect. Is that correct?
That is correct, yes.
And the, I guess would be 2024 biological opinions. Do you understand that those contain additional temperature requirements as compared to the 2019 ones?
That is my understanding, yes.
Um,
There
do
is a
you know,
provision.
go ahead.
I was about to say, there is a provision, I can't, need to find it. There is a component in the feasibility study. It's in the executive summary somewhere that identifies, before we get into actual construction, truing up all of the benefits in a kind of a last true up, recognizing that things may change. And let me see if I can find it. Okay, so in the feasibility study on page 45, there's a statement that says, due to the complexity of the project and the high federal investment, Reclamation recommends validating the feasibility results in pre-construction and documenting any changes in a post-authorization report. So the feasibility study itself recognized that there may need to be a post-authorization report to true up all of the benefits.
And when, can you describe what you mean by a post-authorization report? Is that just post this letter, there will be a supplemental report, or when is authorization?
Oh. I really don't know exactly what Reclamation was envisioning on those pieces. There has been a supplement to this feasibility report. I shouldn't say supplement. There has been one post-authorization report that was submitted by Reclamation to OMB, Office of Management and Budget. I did not include that in my testimony because it has not gone beyond the Office of Management and Budget. It was not submitted to Congress.
It's not submitted, right? Do you know when it was submitted to the Office of Management and Budget?
Sorry, I don't know right offhand, but I do know I could find out. Sorry, I don't have it right offhand. I think it was in the 2023 timeframe.
And I don't know whether you will know this. Do you know whether there is any plan for submission of that document to Congress?
I don't know at this time.
Other than that one document, are you aware of whether there's been any other follow-on analysis conducted or started by Reclamation in this context based on any of the changes that have happened since 2020?
Other than it was called a feasibility addendum. Sorry, I found it. Feasibility addendum. The document that I have is dated November of 2022. So I was off a little bit in the timing. I am not aware of any other supplemental analysis that Reclamation is undertaking, has completed or is undertaking.
And does the feasibility addendum address potential benefits to anadromous fish?
I honestly have not. read the whole thing. I honestly have not read the whole thing. I would anticipate that it would, because that continues to be in our final EIR. And this document was developed at the time we were working on the final EIR.
Does the, sorry, go ahead.
I was going to say, just quickly skimming through it, it continues to include anadromous fish as a benefit within the selected alternative.
All right. Does the authorities, well, let me answer it this way. Do you believe that the volume of reclamation participation in the project as a storage partner will impact the volume or frequency of exchanges with reclamation?
If I recall correctly, from looking at our different alternatives as we had modeled them in the EIR, recall that we had alternatives that had no reclamation investment up to, I can't remember if it was 7 or 9% now. In alternative 1, and then up to 25% in alternative 3. The amount of water exchanged did vary between those alternatives with different investments. So in general, the anadromous fish benefits, the more investments and participation that reclamation has in sites reservoir, the more they are able to achieve the anadromous fish benefits utilizing their own water. The less participation they have in sites reservoir, the more they would be looking to other sites participants to help them generate enough cold water pool storage to achieve those anadromous fish benefits.
I think that's most of the questions I have for you, Ms. Forsyth. Thank you. I appreciate your answers. I may have a couple things to come back to. Ms. Bozzoni, I want to turn to you, and I think where I'd like to start is the figure 3 in your testimony. It's on page 15 of sites 395. So is this, I guess first, right, the numbers in here, are they pulled from a specific year in the calcium record?
No.
Okay. And can you describe for me where the numbers come from?
Um, they they are generally my own creation. I did look at May of a recent year. I believe it was May of 2021. To look at to confirm that there was a month where the delta was in a balanced condition every day of that month, so that I could assume a constant release of 1,000 CFS from the reservoir for my month-long example. So they're generally my own numbers, but were verified that such conditions exist.
Okay. And can you explain where the end of month storage for sites came from?
Really that same kind of concept. It was looking back at estimates of from our historical water availability analysis tool, and it's the end of month storage in sites is really just for illustrative purposes. It's the negative 61,000 acre feet that is really what the focus is there.
All right, thank you. If we could scroll up to paragraph 29 on the prior page of the testimony. At line 3, you describe that in talking about the exchanges, that the purpose is to achieve the objectives or requirements of all 3 projects in an environmentally beneficial or neutral manner. Can you describe what a neutral manner means?
Exchanges, for example, exchanges with Oroville don't necessarily have an intended environmental benefit. That is mostly looking at increased flexibility and delivery from the sites project. However, any exchanges with Oroville would not have like an unintentional negative effect. We would review that action, and it would need to be overall neutral at a minimum.
And what does it mean for an exchange with reclamation or Shasta to be environmentally neutral?
Currently, I don't believe that there are any exchanges evaluated with Shasta that would be environmentally neutral. They are all intended to have some environmental benefit.
Okay. And then that paragraph continues. The exchanges help meet project objectives through flexibility and capacity to move water to storage partners. Project in that sentence the sites project as opposed to the Central Valley or State Water projects?
Yes, sites project.
And is that a water supply benefit?
Yes.
And then you say the next sentence that exchanges can assist the CVP and State Water Project in meeting regulatory obligations, et cetera. And I'm just curious here, the cited document says exchanges have the potential to instead of can? Is there a difference in your mind there?
No, I don't have a different meaning between those two language choices.
And do you agree, I think Ms. Forsyth, with Ms. Forsyth's testimony as well, that the Central Valley project at least is required to meet those regulatory obligations, regardless of whether the site's reservoir is ever constructed?
Yes, and I believe, as I noted, it's another tool that can help them meet those obligations.
Does it allow for them to surpass those obligations, right? Provide colder water than is required under those regulations?
Objection vague. What was the initial it? It allows.
The exchanges, right? The tool that Ms. Spezzoni described?
I don't know.
Are you aware of any indication that it will, right, provide, the exchanges will provide like colder or more temperature benefits than are required by the regulation?
I don't know.
I can speak to this because we addressed this in the final EIR and thinking about the modeling in the final EIR. There's I don't have specifics, but we did look carefully to try to go beyond the regulatory requirement, try to do better for the fish than just the regulatory requirement. So the model sought to meet the regulatory requirement. If reclamation was not otherwise able to do that, it also sought to hold that cold water for longer or have it be colder than what was possible, what was in the regulatory requirement. In this discussion, we've really focused entirely on the cold water pool benefit, but in the final EIR, the modeling also includes fall flow stability, which would benefit fall run Chinook, and enhancing the spring pulse required for spring run was in the 2019 BIOP. I'm not sure if it's in the 2024 BIOP. So for those two, fall flow stability and spring pulse, those were really actions to benefit anadromous fish that were intended to go beyond also what was the minimum regulatory requirement.
And you hinted at this, that the final EIR evaluated that as compared to the 2019 biological opinion, correct?
That is correct, yes.
And I assume, am I correct in assuming that same analysis has not been performed from the 2024 biological opinion from, I don't know, 4 months ago or whatever it is?
It has not been. We're working, as I believe I testified previously, we're working on that calcium 3 model and getting that up and running.
Thank you for that, Ms. Forsyth. I appreciate it. If we could go scroll down to paragraph 31. And the proposed permit term says that there shall not be an exchange with Shasta if it results in the Bureau not meeting applicable laws, regulations, et cetera, in place at the time. Can you explain to me how you determine whether an exchange will result in the Bureau not meeting those requirements in advance?
It would be through modeling. So modeling of the exchange operation and storage of that water within Shasta, and then reclamation's additional modeling for how they anticipate their operations to occur over the year. And similarly with DWR and Oroville.
And is that modeling work that the authority proposes to do?
I believe that both DWR and Reclamation do some form of their own modeling of operations, and I would envision that this would be done with information from the authority to support those analyses.
And I mean, I appreciate that that is a modeling exercise. I'm having a tough time with how to determine that an exchange is going to cause that outcome. Can you help me understand that?
I
Angela,
I think that the intent here is to make sure that there aren't unintended implications of the exchange. And so I think that this would be a rare occurrence, but it's that confirmation before any of the parties undertake the action.
And in the paragraph above the proposed term, you say that the exchanges would only be conducted at certain times, and one of the things you include is contractual deliveries from the projects. And I don't see contractual deliveries in the proposed permit term. Can you explain why that is?
I think that that would be a operational decision of the CVP or SWP operators, and it's not one of the regulatory conditions that would necessarily prevent an exchange from the site's perspective. An exchange with Oroville obviously has to be approved and by DWR, and they have to be willing to undertake that operation. And if they review that and there was a concern relative to contractual deliveries, you have to that would be a decision within their hands, I guess.
Okay. Um, I want to scroll back up to figure 3, a couple more questions here. So am I right to understand that the benefit that the site's authority claims accrues to anadromous fish comes from the increased 61,000 acre feet of storage end of month in Shasta Reservoir?
Yes, so that would be additional water to support the cold water pool in this example.
And if that water was necessary to support the cold water pool, reclamation would have to hold it in Shasta with or without the exchange or with or without Sites Reservoir, correct?
I understand that reclamation has other non-discretionary obligations, and so part of the temperature task group is to review all of those, all of the operations. And if this was a tool in reclamation's toolbox to do an exchange, this can help support their temperature management obligations.
Do you have an understanding of how to quantify the benefit that the authority claims accrues to anadromous fish from the extra 60,000 acre feet of storage in this context?
I do.
Do you have an understanding of how long that benefit would last?
My understanding is that benefits are seasonal, and so this type of benefit possibly through and into the fall timeframe of the same year.
And is the benefit that accrues to anadromous fish in that context, well, let me ask the difference. The benefit that accrues to the Bureau in this context is the flexibility and ease of meeting the requirements, temperature requirements?
I would assume that that's not the only benefit, but is this?
I
Can you
can
can
help
you
a little
oh,
here from the final EIR. I mean, it's sometimes the ease and flexibility. It is sometimes that reclamation could not otherwise meet their water temperature requirements. There just physically was not enough water in the system, or competition between their different obligations of needing to move water into the delta for maintenance of meeting delta requirements at the same time of holding water in Shasta to meet cold water pool and temperature requirements. Were in direct competition with each other. And, reclamation may not be able to meet both of them and have to make choices on which one. And there's sometimes in the modeling where the exchange was able to provide more cold water pool benefits than was required in the regulatory framework, and actually kind of go beyond that minimum. So we saw it as sort of multifaceted in the results of the modeling conducted for the EIR. And we saw some of that in the results done of the NIMS life cycle model, where there were a few years in the life cycle model, granted just a few, that we saw really substantial population increases in winter run that was in combination, and this granted was at the 25% investment, 25% participation. But we had a few years in the winter run life cycle model that showed pretty substantial benefits for winter run of both reclamations. It was a combination of reclamations, investment, and exchanges together that resulted in that. You know, I think this is an example of 1 month to illustrate how this would work. You know, in general, you need more than 61,000 acre feet storage in Shasta to make a substantial shift in the cold water pool in Shasta. But I think this example is really intended to be illustrative of just how physically this would work within the system.
So, fair enough. I mean, I guess when you say go beyond the minimum, does that mean have more cold water, well, more water stored in the reservoir at the end of the year than is required by regulation?
In general, we tried not to have more water stored at the end of the year than is required, because then that water is at risk of spilling, and that, quote, more water would be water potentially tagged for sites participants. So their water would be at risk of spilling. So we were careful in asking the model to try to, any water that was moved in the spring in exchange, to try to move that back out of Shasta in the fall and into the winter, so that it would not be carryover and potentially spill if the next water year was a large, was a wet year.
And is that delivery of water in the fall or later in the year, I guess, from Shasta, that is a water supply benefit to whoever the other end of the exchange was?
It would be, in essence, returning water that was previously stored in another site's member's water account. So in this situation, so it would be District A has 100,000 acre feet and site's reservoir. They agree through the site's authority to participate in an exchange with reclamation. We release their 100,000 acre feet out of sites in the spring. Actually, I should probably use 61,000 acre feet because that's what's in this example. So we release their 61,000 acre feet out of sites in May. That allows reclamation to hold back 61,000 acre feet in Shasta. That 61,000 acre feet is in essence developed under reclamation's water right, but is intended to be returned to that member that originally had it in site's reservoir. So they're foregoing their ability to utilize that water May through whenever reclamation can get that water back to them later in the calendar year.
Correct. And they would then utilize that water that they exchanged in that calendar year, because not like, they could divert it to sites to restore it because of the timing.
That's correct. I mean, to divert it to sites to restore it would have to follow our diversion criteria. We're not envisioning that because it has to follow the diversion criteria, and then we'd be diverting for all of our members. So that we're envisioning that that water would move out of Shasta in that same calendar year, most likely within the transfer window, so by November. And move down the Sacramento River and probably be exported in the South Delta facilities during the transfer window.
Thank you. I appreciate that. So, Ms. Bizzoni, I've just got a few more questions for you. I should be able to wrap up here in the next 5 or 10 minutes, would be my guess. In paragraph 34 of your testimony and earlier today, you described the exchanges as an additional tool for reclamation to meet temperature management obligations. And not as something that's going to change the frequency with which they actually meet their obligations. Is that fair?
So this is in context of the other tools that some of the other tools they've used in the past that I talk about in paragraph 35, involving coordination with the settlement contractors and bypassing hydropower production. And this would be another tool, exchanges with sites would be another tool that could assist them with their temperature management obligations.
And do you envision the exchanges as replacing these tools that are bullet pointed in paragraph 35 of your testimony on the following page?
It may replace or supplement depending on the conditions in a given year.
And if it were to, well, when reclamation in the past has engaged in these three types of actions that you describe, the cost of those actions is either monetary or water supply, correct?
Monetary or water. Yes.
And so if reclamation were you should use the exchanges to limit the number of times that they had to go in those other actions, that would also be a water supply or monetary benefit from hydropower.
I don't believe it's limited to that. There's the temperature benefit. Or downstream flow benefit. So maybe I'm not following your question.
Maybe this will help, right? I mean, if the temperature doesn't change as a result of the exchanges in terms of the water being released into the Sacramento River near Keswick Dam or at Keswick Dam, I'm having a hard time understanding why that's a temperature benefit. I'm having an easy time understanding the flexibility, the water supply benefits. And so if reclamation is increasing hydropower production or not bypassing hydropower production, I understand that as a benefit, an economic benefit. Is that fair?
If these actions were, if an exchange from sites was taken in addition to previous actions, there may be opportunities to meet downstream temperature goals for more days than has occurred during some of these drought conditions, either with cooler temperatures overall or for the number of days. So I believe it goes beyond just water supply and monetary benefits.
And then if we could look at paragraph 38 briefly on page 18. At line 13, you described the temperature management portion of the Sacramento River. Can you just define what you mean by that?
So the upper portion of the Sacramento River, as I note here, is typically 10 to 20 miles downstream of Keswick Dam in that reach. The temperature management plan and the temperature management task group evaluate the operations of Shasta and the available cold water pool. It's my understanding that temperature management and where goals can be met can fluctuate because of the water supply available.
And is that the only portion of the Sacramento River where the exchanges have a temperature impact? Or a potential one?
It's the exchanges for cold water pool benefit are targeted to the temperature management reach of the Sacramento River.
Thank you. I think that's all the questions I have for this panel. Thank you both again for your time. I would make one request that we be provided a copy of the feasibility addendum that Ms. Forsyth referred to. I understand it wasn't part of her testimony, but I think we would like to at least have that submitted, whether it ends up in evidence or not. I don't know that I'm taking a position, but given the testimony today, I would like to see a copy of that, and I did not find it immediately online.
All right, thank you, Mr. Busher. Let's take a break. Let's come back at 3:10 and we will pick up and see if Mr. Schutz has some questions. So we'll see you at 3:10. All right, it's 3:10. I will once again look to our court reporter. Are you ready for us to go back on the record?
Yes, I am.
Wonderful. And I see we are mostly assembled here, and I'll look to you, Mr. Schutz. Do you have questions for this panel?
I do.
Please proceed.
Very well. Good afternoon, Ms. Forsyth, and good afternoon again, Ms. Bozzoni. I'd like to start with Ms. Forsyth. If we could please pull up Ms. Forsyth's testimony, cites
410, I think.
410. It says 41, and I know that's not right. And please turn to page 11. And scrolling down, please. It says here that there are two ways reclamation can use sites reservoir to benefit anadromous fish, correct, Ms. Forsyth?
Is there a specific?
Sure. Let me be more specific. You make a distinction between what you call exchanges that are exchanges between reclamation and another project partner, and simply reclamation's use of its own water stored in sites reservoir that it may use for anadromous fish benefits, correct?
That's correct, yes.
Okay. And I'm sorry, this is some ground we've covered or Mr. Busher covered, but I want to cover it in my own way to make sure we don't miss anything. And as far as sites, reclamation's use of its own water stored in sites reservoir, you don't label that as an exchange, do you?
Context of this water right proceeding. That's just reclamation utilizing its water out of the reservoir. Again, at times, I think the EIR used the word exchange in that context. But from a water right perspective, it is not an exchange. It's just reclamation utilizing its water.
I see, but reclamation would be making an exchange of water sources in either case. Is that correct?
I guess I don't view it that way. If, for example, reclamation uses water out of Folsom to meet its Delta obligations rather than Shasta, I don't know that we call that an exchange. That's just
Okay.
reclamation managing its assets to meet its obligations.
As referenced before about the EIR, you understood, you can understand why the definition of exchange, as you used in the context of sites reservoir, was not always clear to other people, as to the source of the water for the exchange. Is that fair?
Objection, argumentative.
Excuse me, overruled. Please go ahead, Ms. Forsyth.
I'm confused by the question. Can you restate the question?
Sure. Let me see if I can make it simpler. When I used the term exchange in my testimony, I did not intend to make a distinction between water that was owned by reclamation and how reclamation used that for anadromous fish benefits, and water that was owned by someone else that reclamation used for anadromous fish benefits. Do you understand how I reached that? Fail to make the distinction that you make?
Objection, Ms. Forsyth cannot speak to Mr. Schutz's intention and his testimony.
I think that's fair. Mr. Schutz, where are we going on this? I can guess, but I think you've laid the foundation for what is coming next. So I think maybe we can get to what is coming next.
Um, Ms. Forsyth, in your rebuttal testimony, you suggest, as I understand it, that I failed to make in my testimony a distinction between exchanges and reclamation's use of its own water in order to produce anadromous fish benefits. Is that a fair statement?
I don't believe so. I don't believe that I drew that distinction in reviewing your testimony. I do very much appreciate that this has been a little bit confusing in the past. What is reclamation's use of its water and what is exchanges? And so that is why I took the time in my testimony to distinguish between those two. I believe that when I read your testimony, I viewed it as in the totality of the sites project, there was nothing that was in the totality of the sites project that it was uncertain whether the anadromous fish benefits would accrue from whatever mechanism they accrued from.
Okay, let's leave it at that. Thank you. And thank you for the clarification. In whether reclamation were using its own water stored in sites or water of another project partner stored in sites, it would be the initiator of an action for the benefit of anadromous fish. Is that correct?
Objection vague. The initiator of, I'm sorry, I'm not understanding the question is maybe what it is. The initiator of a.
In the actions Ms. Forsyth has described that purport to create benefits to anadromous fish using water stored in sites reservoir. Reclamation would be the initiator of those actions. Is that correct?
I believe so. So reclamation does oversee and manage its storage in sites reservoir, and fundamentally, makes the decision on how to utilize that water consistent with the partnership agreement and our permits and approvals.
Now, even if reclamation were using reclamation's water stored in sites reservoir to initiate an action for fish benefits, reclamation would still need to coordinate with the sites authority regarding the volume and timing of water releases from sites reservoir, would it not?
That is correct. It would be our action to release that water out of the reservoir on at their request.
Could we turn to page 8 of Ms. Forsyth's testimony, please? And at lines 23 to 26. It reads, both Reclamation's participation in the project and parameters around exchanges will be memorialized in the partnership agreement between Reclamation and the authority. Do you see that, Ms. Forsyth?
I do, yes.
So what I'm not wanting to understand what you mean by Reclamation's participation in the project. Does that mean the percent of storage it owns?
Yes. And the contractual arrangement around that percent of storage.
So it also
And so
means, sorry.
yeah. Oh, go
I'm
ahead.
sorry. So it also means how Reclamation interacts with the authority and other project partners. That's its participation in the project. That's part of it.
To some extent, but you know, so here's why I'm hesitating a little bit. We have not started drafting the partnership agreement at all. We have started drafting what's called the benefits and obligations contract. And that is the contract between the authority and I'll say the non-federal, non-state of California participants. We anticipate the partnership agreement to be similar to the benefits and obligations contract, but because we have not started drafting it, there is a little bit of, I think my answers need to be held in that, and thought of in that context. We would envision that the partnership agreement would touch on a bit about Reclamation's relationship to the other participants, but mostly probably to the extent that Reclamation's use of its 16% could not impact the ability of other participants to utilize their accounts. If that makes sense.
I think it does. When you were speaking earlier with Mr. Busher about what I understood you to say is as having part of the partnership agreement be specific to Reclamation. Does what you just described about not affecting other project partners, is that part of what would be specific to Reclamation in the partnership agreement in your mind?
I don't recall the specific context of the discussion with Mr. Busher. However, the partnership agreement is between the authority and Reclamation. We're not envisioning that there would be, at this time, my understanding is that we are not envisioning that there would be any other signatories to the partnership agreement.
All right, that's a useful clarification. Thank you. And at the top of page 9, if you'd go there, please, Ms. Mullen. You say the partnership agreement will not bind or control Reclamation's use of its storage allocation, other than to require that this be consistent with the authority's permits and approvals. By approvals in this context, do you mean having the project approved for permitting, construction, and operation, or do you mean the approvals of the authority or by the authority of specific actions requested by Reclamation in using its stored water?
So in this particular context, I am referring to I'll say like regulatory permits and approvals. So the project operations ITP permit, eventually the project operations biological opinion or water right permit. The partnership agreement will likely refer to the operations plan for specifics of day-to-day operations, like how does reclamation schedule water to release out of the reservoir? You know, how will the authority evaluate those things? But the agreement itself won't bind how reclamation can use that water, as long as it is within the, as long as the authority can legally do it, and it's within our permits, it fits within our regulatory permits and approvals, and we can physically do it. We are intending to work to allow our members to achieve that.
I see. So approvals here in this context on line 2 means your overall approvals for the project. Is that fair?
That is, yes, what I
Thank
had envisioned in writing this sentence.
Thank you. So on lines 3 and 4, you go on to say the partnership agreement is irrelevant to determining water right permit terms and conditions. Won't the partnership agreement inform whether there are mechanisms in place by which reclamation can actually carry out its purported fish benefits?
I guess I look at it the other way around to say, if the water right permit for the authority, for example, says, and I'm just an example, it says no exchanges are allowed. That would limit reclamation's ability to achieve the benefits out of sites that it is looking to achieve. So I look at it the other way around, that if, you know, if conditions are imposed on the project such that any of our members can't fully achieve their benefits as they have envisioned, or as the authority has envisioned, that becomes the controlling document, not the other way around.
Okay, I think we're seeing this from different ends of the problem. So even if there aren't terms that could bind reclamation, couldn't there be permit terms that bind the site's authority to cooperate with reclamation positively?
So I think I understand the question to be, could there be terms in our water right that require the authority to cooperate with reclamation? And if that's the question, then I think, yes, that is possible. And I think we ourselves have proposed some of those terms, say in our CVP State Water Project term. Now that's more about avoiding impacts to the CVP.
So more specifically, to cooperate with reclamation in terms of allowing it to use site's reservoir to provide anadromous fish benefits.
I guess I'd have to think, I'm trying to think about what a term would look like around that, and how that would be formulated. There are reclamation's use of its own account in sites. It's quite easy for reclamation to utilize that and provide those benefits, because they're actually utilizing their account generally at a different time than the rest of our members. Like they're wanting to release water earlier in the year, which really actually helps balance, because we're trying to limit our environmental footprint and building new facilities. So spreading out those releases over a longer period is helpful to us. Terms, for example, that require the authority to participate in an exchange with reclamation, potentially those exchanges, as I testified previously today, have the potential to result in spill from Shasta if that water is not moved out within the same calendar year. Which means that our local water agencies, our non-federal, non-state water agencies may utilize or may lose some very valuable water to them. So our other participants may find that very undesirable to be forced into those exchanges.
I understand some of the particulars that you're describing and the interests at play. On the other hand, is it your opinion that it would be in the public interest to have some kind of binding requirement on the authority in regards to reclamation that would at least help make the purported opportunity for anadromous fish benefits actually happen?
So 2 things on this. I think that binding requirement comes from the fact that these benefits are in the federal feasibility study and in the NEPA document. This is how reclamation has described how they want to utilize their water out of Sites Reservoir, and to achieve, to conduct certain actions, they have to have that compliance. The authority did seek to actually have this as a benefit in our Prop 1 application, and we sought funding for this benefit, and ultimately it was not determined to be a benefit by CDFW because they were concerned about binding reclamation in this way. They didn't feel that the authority could guarantee that benefit. I think the authority would be interested in providing anadromous fish benefits. Our members have stated a number of times at our authority board meetings that they're very interested in these benefits. They also are looking at the risk of that, in that they have a fiduciary responsibility to their own ratepayers.
So, okay, thank you for that. Why don't we move on to what you believe is binding on reclamation? You talk in your rebuttal about the WIN Act and NEPA and how they make it likely that reclamation will use Sites Reservoir to provide benefits to anadromous fish. Can you point to any language that actually binds reclamation to having such benefits?
If we are talking about binding as in thou shall, there is no discretion as we think about some of our statutory language that says thou shall. There is not language in the WIN Act or in NEPA that is thou shall. I think the WIN Act and NEPA provide an indication that this is reclamation's intent. This is what they have told Congress they are going to do with their participation in Sites Reservoir. And this is part of the project that they have covered from a NEPA perspective. and that we will ultimately cover under federal ESA also.
So corollary to that, there isn't an entity that could enforce an alleged requirement for reclamation to benefit, to use sites to benefit anadromous fish because there's no binding requirement. Is that fair?
I don't believe there's an entity that could force reclamation to use their water in a certain way.
Thank you. I think I'll leave it at that with Ms. Forsyth for the moment. Thank you very much. And I'd like to turn back to Ms. Bozzoni. Good afternoon again, Ms. Bozzoni. Could we please turn to figure 3 at the top of page 15 of Ms. Bozzoni's rebuttal testimony? I know Mr. Busher went through this with you considerably. I'll try not to prolong it more than necessary. Ms. Bozzoni, you show here a hypothetical exchange between Sites Reservoir and Shasta Reservoir in May of a critically dry year, correct?
Correct.
Okay. And you show a release of 1,000 CFS from Sites Reservoir and a reduction in release from Shasta Reservoir of 1,000 CFS. Correct?
Correct.
Okay. Ms. Bozzoni, couldn't the same savings in Shasta Reservoir without decreasing flow downstream of Knight's Landing be achieved by decreasing deliveries out of Shasta Reservoir between Keswick Dam and Knight's Landing?
I think it would depend on the specific hydrologic conditions of that year and allocations to water service contractors such as the members within TCCA. Many of the example years that I had in mind while developing it, this figure, that allocation was 0%. And so there is not the opportunity, for instance, to decrease that in order to result in a water savings, I think was maybe what you said, or I made that up, but an equivalent reduction in releases.
Mm-hmm. So it would have to come from more senior contractors like the Sacramento River settlement contractors in order to achieve this. Is that correct?
Similar actions have been achieved through voluntary actions by those Sacramento River settlement contractors, which is noted in that list of actions in paragraph 35 that I mentioned previously.
Okay. So what's achieved by your diagram is that you maintain the water supply deliveries between Keswick and Knight's Landing, whatever they are. That's one of the effects. Is that correct?
This scenario assumes that there are no changes within the system other than sites releasing the amount that can be withheld in Shasta. So this is a simplified scenario that assumes no other changes between the left and right-hand side.
So in that sense, what's happening here is that there's a water supply benefit to whoever is diverting water, Central Valley Project water between Keswick Dam and Knights Landing. Is that correct?
Ms. Bizzoni, you are muted.
Am I unmuted?
Yes.
I hit the space bar. I didn't know that muted me. Uh, no, I do not see this as a water supply benefit to any diverter along that Sacramento River reach you mentioned. This is an action that can be taken using Sites Reservoir that results in no change in diversions along that reach.
Do you not think there's a water supply benefit in not reducing water supply?
Objection, vague, overbroad.
In this context, is there not a water supply benefit in not reducing water supply deliveries between Keswick Reservoir and Knights Landing?
Nothing in this example is implying that there was an exchange of reducing water supply to someone else for this to happen. This is water being released from Sites Reservoir and an equivalent amount being held in Shasta while all other operations remain the same.
I understand. Okay. Can we go to the top of page 16 of Ms. Bizzoni's testimony, please? And actually, at lines 16 to 18. And this is not looking correct to me. Ms. Bizzoni, perhaps you can help me find it. You note that there is no reason that the water cannot achieve anadromous fish benefits below Keswick Dam and then provide a source of water supply for downstream diversions. Do you recall where that is in your testimony?
I believe that's paragraph 38 on page 18.
Maybe 18. That sounds good. That's correct. Thank you. So here you're talking about achieving water supply benefits and anadromous fish benefits, providing multiple beneficial uses, correct?
Yes, sorry, read the whole sentence.
Okay, I'm sorry. It's on lines, the multiple beneficial uses
Yeah.
on
Yeah,
lines
I
18.
14 to 18. Yes, that's generally the end takeaway here.
But Ms. Bizzoni, isn't it true that in the cases, some of the years you cite, like 2014, 15, 21, and 22, there were almost no benefits to salmon from the drought actions of reclamation in those years?
I cannot speak to whether there were almost no benefits or not. I would assume that conditions without those actions would likely have been worse.
So could we please pull up CSPA 7, the February 3rd temporary urgency change order that Ms. Bozzoni cites on this page? And turn to page 16, excuse me. Page 11. Now, if you zoom in on the top paragraph here, starting on the fourth line, it says, despite temperature modeling that indicated that temperatures could be maintained below 56 degrees, temperature control was lost before the end of the egg incubation life stage. As a result, the 2014 winter run brood year is estimated to have experienced 95% mortality. Do you see that?
I do see that.
Ms. Bozzoni, to your knowledge, did any of the winter run brood years in 2015 or 2021 or 2022 have mortality rates less than 90%?
I do not know. I do not have knowledge regarding that. However, as I mentioned, I would have to assume that without any actions, these occurrences may have been worse.
Could we go back to Ms. Bozzoni's rebuttal testimony and look at page 17, please? And on lines 5 to 8, you list a number of measures that the Sacramento River Temperature Task Group and others took in order to improve temperature conditions in the Sacramento River, correct?
Correct.
And does any of these measures that you identify involve a loss of water supply?
Yes, from my perspective, they do, particularly the requests with the Sacramento River settlement contractors to delay their spring diversions. That did reduce an overall reduction in the amount that those growers were able to apply, or in some instances, I believe it was made up by groundwater pumping, but this was overall a decrease in water supply, as well as the encouraged participation in water transfers. I recognize that there is a monetary benefit of those water transfers, but that's in exchange for water supply that these farmers would have otherwise used to grow a crop. And there's resulting implications when many of these farmers don't grow a crop for a given year.
Could we go back to the top of page 16 of Ms. Bozzoni's testimony? In lines 4 to 9, Ms. Bozzoni, you call out my statement that it is entirely at Reclamation's discretion how it manages Shasta Reservoir. Are you taking me to mean in that passage that my testimony suggested that reclamation has discretion to ignore requirements?
I think that there are requirements of reclamation's operations that are not fully at its discretion. And the main regulation or this mostly is in regard to the water rate orders 90-5 and 91-1 that impose those temperature management requirements. So that is not at their discretion.
They have to comply with certain requirements, but isn't it at their discretion how they comply?
Objection includes testimony, assumes facts not in evidence, or lacks foundation.
I'm going to say overruled. I think we understand the point here. Go ahead, Ms. Bozzoni.
I don't believe it's entirely at their discretion. It's through the collaboration of the Sacramento River Temperature Task Group and the development of the annual temperature management plan.
But historically, in those years that you've mentioned in your testimony, 2014, 2015, 21, 22, there was not an entity that told reclamation, you must do this or you must do that in order to comply, was there?
I am not entirely familiar with the inner workings of the task group, so it's my understanding is that they develop the temperature management plan and take those actions.
Let's move on to South Delta diversions, please. And in this regard, did the AHO receive an exhibit from me this morning? I didn't get a confirmation.
I believe we did, but I will confirm.
We did.
Thank you. Okay. So could we please look at Ms. Bozzoni's rebuttal testimony on page 19, lines 20 to 22? You state water transfers, or in this case, the rediversion of water released from site's reservoir, do not allow DWR or reclamation to violate conditions opposed by regulatory agencies. Do you see that?
I see that sentence.
And you also say, if we could go to page 24, on page 24, and on here, let's just stay there. Excuse me, I'm sorry. And on on page 20, line 21, line 1, excuse me. Do I have the right? No, that's not correct. Can we try page 24? I don't have the citation, and maybe you can help me find it. I have the quote that says, similarly, rediversion of site's water is subject to the regulatory requirements imposed on the projects in D1641.
You were right at the first location. It's the bottom of page 19, line 24, and continuing on to page 20.
Thank you very much. So could we now please pull up CSPA 106, which I sent earlier? So this is the title page. This is the temporary urgency change order from March 5th, 2015. Do you see what we're looking at, Ms. Bozzoni?
Yes.
And could we please turn to page 30? And if we'd scroll in on sub 2 there, and that's, don't please, yeah, there you go. That's great. So generally, I'm going to represent to you that this is an order allowing DWR and reclamation to not comply with D1641 under an emergency condition. Do you understand that? Does that make sense to you?
I would disagree that this is them not complying. This is them requesting and being granted modification of the requirements in D1641.
Okay. And could we scroll in on, zoom in on sub 2 there, please? Great. So at the top in the non-highlighted section of sub 2, it limits DWR and reclamation from exporting water above 1500 CFS with an exception. Do you see that?
Yes.
And then if you go down to sub E, it says, these export limitations do not apply to water transfers. Do you see that?
Yes, I do.
Okay. And where it says under non-SWP or CVP permitted licensed rights, that's been redlined out, correct?
Yes.
Stricken.
Yes.
Okay. All right. Um,
However, there is a process noted, so there's more to it than this one sentence or two sentences.
I'm sorry, I don't follow you. Maybe you'll have to explain.
Well, the first sentence says that these export limitations do not apply to water transfers. But it continues to say that based on additional information or changed circumstances, they may be modified through a process described below. So I guess I'm not sure. I guess my point was there's more to this than the single sentence.
There's a chance that it could be modified and it has to go through a process. Is that fair?
Yes, and yes.
Okay. So this is an actual temporary urgency change order that was issued. And I'd like to think about this in the context of sites. In this order, reclamation under this order is limited from exporting water, project water, beyond certain limits, correct?
Objection seems to be a line of questioning that lacks foundation. Mr. Schutz has not shown that Ms. Bizzoni is qualified to answer these questions or otherwise has familiarity with the facts in this document.
Ms. Bizzoni has submitted testimony that says that how conditions placed on transfers during droughts should be left to the specific situation. I'm looking at one specific situation that was where this actually took place. And asking her questions about what happened in actuality, not in the hypothetical. And I think it's within the scope because she introduced how she thinks the board should deal, generally speaking, with temporary urgency changes.
And I think the objection, Mr. Schutz, was not to the scope, was not relevance, but was to Ms. Bizzoni's understanding of this order and the facts that have or have not been established with respect to this particular example. Is that fair to say, Ms. Chester?
That is correct. Thank you.
I'm curious about this line of questioning, but I'm also concerned that here's my concern. Maybe you can work around it, Mr. Schutz, that Ms. Bizzoni is being asked to answer questions about a set of facts that she's not familiar with. So I'm not sure
Before we
lead us
establish,
through it. It may work, but that's
before we do that,
okay.
Ms. Bizzoni, are you familiar with this document?
I'm not as familiar with this one. I probably was in 2015. However, I will note that I refer to specifically two orders regarding TUCPs that were issued in 2021 and 2022. Perhaps those would be better to bring up as they are more recent than this one from 2015. And they are what I referred to in my testimony.
So here, Mr. Schutz, I think you can go forward. I think fair enough for you to choose your order you'd like to investigate. I know they may differ in some ways, or I suspect. But let's try again now that we've gone through that exercise.
So you're familiar with the orders from 2021 and 2022. Were, to your knowledge or to your recollection, were different conditions placed on transfers in those orders or in any of those orders, because there were probably multiple orders, that are placed here on transfers?
I don't know. So in those, both of those orders, there was term 1D2 that I think is very important, that requires a detailed accounting for water transfers being submitted to the state board prior to the movement of any water or export of any water transfer water. And I am not aware, I just don't know if a similar term was included in this order. And I think that that's very relevant to the discussion. So if we could verify if that term is here, then I would, yeah, I'm sorry, I'll stop.
It would take me a moment to ascertain whether that term is here or not. I think that the broad question is, are there circumstances in which transfers are not subject under TUCPs to the same restrictions in volume that project water is?
Objection overbroad.
I'll allow it, but based on your knowledge, Ms. Bizzoni.
I'm sorry, can you repeat the question?
Yes. Are to your knowledge, in later orders, 2021 or 2022 temporary urgency change orders, are transfers subjected to the same restrictions in volume as project exports?
I don't consider them to be. It's kind of, I guess, apples and oranges. There's in these orders there, and in the TUCP themselves, there are actions outlined for what DWR and Reclamation can export under their own water rights. And then there is a request for the approval of movement of transfer water that is outside of and beyond their water rights. So the TUCP is specific to DWR and Reclamation water rights. But there's this additional piece, this transfer water that is not under their water rights. And in the more recent orders, there is a very specific process that has to be undertaken prior to movement of water under others' water rights. So it's part of the petition and it's a consideration of the order. They're not in the same bucket.
Part of a petition, which petition are you referring to?
The TUCP.
Okay. But there is a process by which transfers can take place even while project exports are limited. Is that correct?
Yes.
So would you anticipate that same opportunity would exist for sites water?
Objection, vague, calls for speculation.
Would the sites authority seek to include releases from sites for export south of Delta in the same category as transfers during the pendency of a TUCP?
I think that is a reasonable path forward and is the in paragraph 50 of my testimony, lines 1 through 7 address that.
Right. I mean, you would find it objectionable for that opportunity not to exist, to state it differently. Is that fair?
Correct. A TUCP is filed by DWR and Reclamation for their water rights, and that a water right held by the site's authority is not their water right. And so if we are requesting to use available capacity at the South Delta export facilities, it should be evaluated in real time, consistent with the movement of other non-project water.
So let's consider the case where the water from sites that's being moved would be Central Valley Project water or reclamation water. What restrictions would you seek, if any, on that particular water?
That is still water appropriated under the site's authority's water right. It would be non-CVP water. They use it, what we've called CVP operational flexibility, but it is not appropriated under their water right.
So effectively, water owned by the Central Valley Project could be exported by virtue of its being stored in Sites Reservoir, even when Central Valley Project water was constrained, if it were water that was diverted pursuant to the Central Valley Project. Is that correct?
It would
Objection.
have, oh, I'm sorry.
Go ahead, Angela, if you can answer.
I think it would have to be evaluated by the State Water Board through this process that I have mentioned, and that they have required in the prior TUCP orders. So it wouldn't be some automatic process. It requires review during those conditions.
I really quick though, I just want to be careful on this because Mr. Schutz, your question said, I thought I understood your question to say Central Valley Project water stored in Sites Reservoir.
I misspoke. I meant reclamation water. You're absolutely right.
Okay, thank you.
And I believe Ms. Bizzoni understood that to be my meaning.
Did interpret it that way, but good
Thank you.
clarification.
And I apologize for my lack of fluidity, but there you are. And I am done with these witnesses. Thank you very much.
Thank you, Mr. Schutz. With that, I will ask whether there are any other representatives of the coordinating NGO parties who has questions for these witnesses. And I don't believe we have other tribal representatives online, but do I have any who have questions for these witnesses? With that, then I'll look to Mr. Reese. Do you have questions?
I do have some, but were we gonna take a short break or just power on?
Well, I'll look to the witnesses. That's really Ms. Forsyth and Ms. Bizzoni, especially Ms. Bizzoni, you've been here all day. How are you doing?
I would love even just a 3-minute break to refill my water cup and be right back if that is acceptable.
Let's go with 5 and we'll come back at, I'll put it at 4. It's going to be 4:18.
Okay, thank you very
Thank you.
much.
All right, I'll look to our court reporter. Are you ready for us to go back on the record?
I am, thank you.
Thank you. Mr. Reese, back
Yes,
to you.
good afternoon. These questions are just for Ms. Bozzoni, and I seek to be brief. Calling your attention to paragraphs 46 and 47 of your testimony. Cites 395. There you talk about this additional term that the authority requests be included in its application, and I won't read the term, but it pertains to rediversion at Clifton Court, Forbay, and Jones. And then you indicate that the term requires compliance with the water quality response plan, water level response plan, and you say the 2018 Bay Delta Water Quality Control Plan update includes implementation activities associated with the lower San Joaquin River flows and southern Delta salinity, including development of a comprehensive operations plan, which is a COP, and monitoring special studies MSS plan to assess the dynamics of water level flow and salinity conditions to inform that COP. And then you go on to say that you think it's your understanding that the COP may incorporate or supersede current plans. Do you know when the MSS and the COP were supposed to be completed by?
I do not know when they were supposed to be completed by off the top of my head. It is my understanding that that date has passed.
Okay. It's my understanding that they're supposed to be completed within 18 months of their submittal to the Office of Administrative Law in 2018, which would make them approximately 5 years overdue. Do you have any reason to dispute that?
No.
Okay. And do you think, or rather, in your opinion, do you think that plans and studies that are nearly 5 years overdue can reasonably be relied upon to ensure that rediversion of water at Clifton Court, Forbay, and Jones Pumping Plant won't injure other users of water?
I'm sorry, I'm not sure I followed the question. Are you asking if because they're overdue, if I think that they won't be adequate?
No, I'm asking you, in your opinion, do you think it's reasonable to rely on plans and studies that are now over 5 years overdue? Is it reasonable to believe that those plans will help prevent injury from the rediversion of water, injury to water right users from the rediversion of water?
Well, in regard to sites, the project wouldn't be operational for another 8 years or so. Hopefully there may be a comprehensive operations plan by that time. However, in the meantime, there are the existing water quality and water level response plans in place.
Okay. Looking at paragraph 49 of your testimony, we're getting back to talking about this term 1D2 that you've indicated was in the recent TUCP orders from 2021 and 2022. Looking at this term, it appears to give, or as you've recorded it here, written it here, do you think that in your opinion, do you think that 5 working days is a reasonable amount of time for the board and effective parties to evaluate the proposed or the effects from the proposed transfer?
I'm just reading the term. So can you repeat your question?
Yeah, my
Now
question
that
is,
I've read it.
yeah, just, do you think that 5 working days is a reasonable amount of time in advance of the proposed transfer occurring for the board and affected parties to evaluate the effects of the transfer?
So the petitioners, being DWR and Reclamation, should have performed that evaluation and be providing the support. So if the data or information isn't being provided to the state board and others to just say, here you go, this is what we're doing. It's along with an accounting and analysis and information to support that it will not cause injury to other legal users of water or unreasonable impacts, etc.
But it only has to be provided, that information only has to be provided 5 working days prior to the transfer occurring. Is that correct?
At least 5, yes.
Okay. And so just again, do you think that's in a reasonable amount of time for affected parties to have an opportunity to evaluate the effects of the proposed transfer?
I would say yes. I feel that things during drought conditions happen very quickly. They're kind of all hands on deck situations, and as this appears to be a term that's used time to time, I don't think it would be an unexpected analysis that comes in for people to review, and I think that these actions have to be taken very quickly in drought conditions.
Okay. Looking at paragraph 53 of your testimony, you're responding there in paragraph 53 to Mr. Wilson's suggested amendment to the place of use to eliminate the CVP areas that drain to the CVP. Are you aware of any analysis associated with the sites application that shows delivery of sites water to CVP contractors won't increase ag return flows to the San Joaquin River?
The sites analysis maintains current land use, and although it's not something that I reviewed in detail, I think that it would be unlikely to increase return flows in the years where water can be delivered due to the reduced water supply conditions that would exist.
Yeah, I appreciate your opinion in that regard. Are you aware of any specific analysis associated with the application that would show that, and that being that the delivery of sites water to the CVP contractors won't increase agricultural return flows to the river?
I am not sure if that is included in the CalSim 2 analysis.
Okay. Are you aware of any laws or regulations that would require CVP contractors to reduce their groundwater pumping as a result of receiving sites water?
Objection. Calls for a legal conclusion.
I just said, are you aware of any regulations or laws? I didn't ask for her legal analysis of it.
No,
Go ahead.
I'm sorry. I didn't let that finish.
I think we're done. To you, Ms. Bizzoni.
No, I am not.
And does your opinion, this is all about paragraph 53 of your testimony, and does your opinion that the delivery of sites water to CVP contractors is unlikely to result in increased return flows? Does that assume a direct replacement of groundwater pumping with sites surface water?
Direct replace. Direct replacement. Are you asking me if it would be a 1-for-1?
Exactly, yes.
Okay, okay. No, no, I think that that may be a possibility, especially when we're looking at irrigation of permanent crops. If there's surface water available, you may reduce your groundwater pumping in a like amount, but that is not the only that 1-for-1 replacement wasn't the only thing I had in mind. It's just that there may be an overall reduction of groundwater pumping.
Is there other things you had in mind that are responsive to the question?
The limitation, sorry.
All right.
My brain is a little fried. It really, it's lines 24 and 25 here on the page that we have up, that the irrigation districts actively manage that drainage. And so that, coupled with a reduced water supply from other sources, would likely not result in an overall increase to return flows.
Okay. Now you talk about the practices, and I think in this line 24 and 25 of these other irrigation districts. Do you have any direct evidence or any specific evidence that the practices you refer to in paragraph 53 actually reduce return flows to the river?
What I looked at was in the footnote that's at the end of this sentence on the following page, that there has been a trending decline in salinity in the San Joaquin River that I believe supports the results that these actions are meant to provide.
And those actions, you're referring to the various practices from the districts you referred to?
Yes, and I'm sure that there's other actions being taken as well.
Okay, and looking at, you mentioned this footnote 21. Does the trend that you refer to, or that you characterize as footnote 21, does that trend tell us anything about how sites exported water would actually affect San Joaquin River EC at Vernalis?
It does not.
Does that trend tell us anything about how sites water exported sites water would affect EC at any other location in the South Delta?
I think that the trend really shows the actions taken by these entities, and that we wouldn't see or expect to see delivery of additional surface water making a significant impact, but this is simply a trend of how the actions have affected salinity over, I don't remember the years. I believe it was about 20 years of data.
Do any CVP service areas in the San Joaquin Valley drain directly to the San Joaquin River?
Are you asking me if all return flows go through sumps and constructed wetlands?
No, I'm asking you if you're aware of if any CVP service areas drain directly to the San Joaquin River, drain in terms of agriculture return flows.
I do not know.
Okay. Do you know if delivering water to CVP service areas in the San Joaquin Valley cause subsurface accretion of water to the river?
I have looked at one of the groundwater sustainability plans in the area, and that plan noted that the San Joaquin River reach within that subbasin is a losing stream, which in my mind implies that at least that reach would not be receiving subsurface accretions.
Okay, and do you have knowledge of the other reaches of the river, or is that your conclusion regarding all of the river within the CVP service area?
It was a limited review of the one subbasin, and I can't remember it off the top of my head.
Okay, fair enough. Do you know if the EC of the San Joaquin River water upstream of Vernalis determines how much water the Bureau of Reclamation releases from New Melones on the Stanislaus to meet the water quality objective for Vernalis?
I am not familiar with New Melones operations.
Okay, all right. Then let me ask you another question. If you're not familiar, we'll move on. Per the site's analysis, do you know, or rather, does the site's exported water to CVP service areas in the San Joaquin River ever increase the need for releases from New Melones to meet the Vernalis EC standard?
Objection vague. Are you referring to a specific site's analysis?
Yeah, the entire site's analysis with regard to the application.
I do not know. I think that if it was evaluated in our calcium 2 model, but I don't know.
I think you said, and I won't go on, you're not familiar with the New Melones operations.
No.
Correct. All right. Can you point to any site's testimony or analysis that examines how any deliveries to the CVP service area of site's water will affect EC in the San Joaquin River at Vernalis?
I would have to assume that the DSM-2 model would consider that Vernalis would be a boundary condition in DSM-2. But I can't answer beyond that. I don't have that familiarity with the DSM-2 model.
Fair enough. Similar question, and I'm just about done. Similar question, are you aware of any site's testimony or analysis that examines how any deliveries to the CVP service area of site's water will affect EC at the 3 interior South Delta locations where water quality is monitored?
Same answer.
Fair enough.
You said the delivery to those lands. Yes, then same answer.
I don't have any further questions for you, Ms. Fazzoni. Thank you.
Thank you.
Mr. Reese, did you have? Is that the end of your questioning?
It is. I didn't have any questions for Ms. Forsyth.
Okay, thank you. Thank you, Mr. Reese.
Thank you.
We're close, but I am going to press on because we need to get through as much as possible. So I'm going to look to Mr. King If you have questions for this panel, which I assume you do, you may start, and I assume we may have to finish on Monday morning, and we'll plan to do that.
I'll go into the Monday. I imagine altogether 45 minutes, an hour.
Okay.
Thank you. And my question is really going to probably be for Ms. Forsythe. So Ms. Forsythe, and I think Ms. Chester for making and for you, presiding officer Kenzie, for making the changes to the testimony in regards to excluded evidence. Ms. Forsythe, can we just sort of give me the framework picking up from 11? And I'm starting since we excluded the first 10 paragraphs. Recognizing authority's commitment in the Maxwell Irrigation District Agreement, development of creek operations plan, and its value of trust and integrity for local communities and strategic plans. And it goes on there. So what is the importance of the Maxwell Irrigation District? Does that still have importance, the agreement for the Maxwell Irrigation District? When it comes to the rest of this?
Well, I think the relevance of the Maxwell Irrigation District Agreement is that it does require development of a creek operations plan. In that case, it was envisioned to be with Maxwell Irrigation District. And it kind of generally said, and other parties. And so I think that intro was intended to identify that what we have offered to Maxwell there and having that agreement, we would work to offer to all downstream water right holders.
But would you agree that the Maxwell Irrigation District and the exhibit to it, which is the there's two exhibits. One exhibit is the water rights and the other one is the operating procedures, are just limited to the creeks, Stone Corral and Funk's Creek, and does not refer to Inclusive Basin Drain or anything below the Stone Corral Creek confluence with the Inclusive Basin Drain?
I would have to look back carefully at the agreement to see if it refers to the Coosa Basin Drain. I guess in my mind, it is difficult to write a creeks plan without thinking about the drain. Meaning the Maxwell ID agreement may focus more on the creeks because their diversions and their water rights that the project could affect are on the creeks. But I think in writing a creeks operation plan, you would need to think about the downstream locations also.
Yes, I think that's that's the reason I'm asking the question. So thank you, but I don't see any reference to anything other than the creeks in this agreement. I think there's not one reference to Coosa Basin Drain as far as I've read it through a couple times. Do you think I'm correct on that?
Objection, testimony without a foundation or really directed to we can bring up the documents perhaps.
Okay, yes, it cites 411. Thank you. So maybe well, Ms. Forsythe, do you know of a place where there's discussion of the Coosa Basin water rights downstream to either Stone Corral or Funk's Creek in this document?
So this document addresses specifically concerns expressed by Maxwell Irrigation District and discussions that the authority had with Maxwell Irrigation District. It is not intended to address all of the creeks or the Coosa Basin Drain. Maxwell Irrigation District's diversion location is on Stone Crow Creek, functionally kind of at its confluence with the drain. So it does not address the drain specifically because it wasn't within the scope or the relevance of this particular agreement. I will say if we go to page 4, paragraph 5A, this is where we include the Function Stone Crow Creek operations plan. And in kind of that 1, 2, 3, that into that first, into the third line, start of the fourth line, we identify that we would be developing the plan in cooperation with MID, which is Maxwell Irrigation District, and other interests. So there was really no reason for this plan to address the Colusa Basin drain because that was not within the purpose of this
Okay,
agreement.
okay. Can we go then to page 10? And Ms. Mullen, could you straighten that, turn that, great. And so Ms. Forsythe, so these are this is all the water rights held by Maxwell Irrigation District. Is that correct?
That is my understanding, yes.
Okay. And if we look at the bottom row, application number 3445, that has a permit number of 2104, and the is that right? The priority date's May 30th, 1995?
That's what this document states, yes.
And it does have I guess 3 points of diversion on interior and then 1 point on the river. So total 4 points of diversion. Is that correct?
That is,
Can we scroll down just a little bit, please, Ms. Mullen? I think we're looking, thank you. Perfect.
that is correct.
And Lurline Creek is also a tributary to the Colusa Basin drain. Is that your understanding?
I am not familiar with Loreline Creek, although many of those creeks do flow into the drain.
Right, right. Okay. You're
Well,
not.
actually, if you look at the map on the next page,
Yeah.
Loreline does flow into the drain, yes.
Great. All right.
It's
okay.
gonna be at the bottom of the map.
Great. Okay. And has this water right been subordinated?
The authority did agree to subordinate to that. When you say this water right, I think you're referring.
The
sorry, Ms.
the
Long, go
permit
back up.
permit 3044, permit 30445 with a priority date of May 30th, 1995.
Yes, the authority did agree to subordinate its ability to divert to Maxwell ID's ability to divert
Right.
under this water right.
And is your understanding that the 3 appropriate rights that is your understanding that TMM King Farms has 3 appropriate rights that are not subordinated right now? Is that correct?
That is my
Justin-
understanding.
Oh,
Sorry.
Go ahead, Ally, if you can answer.
That
And-
is my understanding.
And by the operation of site's agreement to subordinate that 1995 priority date is subordinate to the 3 T&M King rights, which have 1980 and 1982 priority dates. Is that correct?
Objection, states facts not in evidence.
Okay, thank you. So then let's go to bringing the foundation for that. Can you bring up bring the right thing? Where should King 61, Miss Mullen? Yes. Under the page. Apologize, I thought I had it set out. Okay, yeah, that's right. One. What did I do now? I can't find there's these are, I guess let's just start, can you? Misplace my,
If I may, Hearing Officer Kenzie, I would note that to the extent that this line of questioning relates to Mr. King's specific water rights and Ms. Forsythe's rebuttal testimony that was removed, paragraphs 5 through 10, we would object on the grounds of relevance.
No,
Understood. Thank you, Ms. Chester.
it doesn't, it relates to this paragraph, but I just have to, I misplaced my, okay, let's just go down this, if we scan down this exhibit. Just keep on going, Ms. Mullen, I'm sorry. So, Mrs. Forsythe, do you recognize these series of emails between yourself and Rebecca O'Brien and Kyle Knutson at MBK?
I do. I believe it's Rebecca Smith.
Rebecca Smith, I'm sorry. Yeah. And so, do you remember requiring, do you remember the focus of this was have to have a letter issued by Mr. Brown to Doug McGeegan, who was president of the Coosa Drain Mutual Water Company, regarding rights on the Coosa Basin Drain? Yeah, we'll just keep on scrolling down then. You don't remember that?
So these series of emails and letters was an effort that the authority undertook with the Coosa Drain Mutual Water Company before we had submitted the water right application. I believe before we had submitted.
Yeah.
Uh,
Just keep on going, Miss Mullen.
What is the purpose of, what are we scrolling for, Mr. King?
Well,
What are you looking for?
Yeah, so one is just it talks about the plan, the operations plan, and the integrity and respect for local communities and strategic plan.
So you're looking for a specific email?
Yeah, it just, well, what I'm looking into, so Miss Forsythe, you required to subordinate that actually you could, what water right holders couldn't protest if that was in your letter. Isn't that correct?
Objection, vague.
Okay.
Yeah, we need the document, Mr. King. I'm
Okay.
sorry to say.
Yeah, I took away a lot of my papers and then I took away the part that I really need. So keep on going down. I'll find it here. We'll keep on going down. There's several versions of this. Okay, well, this just is one. This is exhibit. Can we, Ms. Mullen, can you straighten this up?
yeah, the signed letter begins on page 18.
Okay. And this is exhibit to the letter, is that right?
This is page 17, so I don't think it's an exhibit to the letter on page 18. Shall we go to the letter on page 18?
Okay.
Thank you, Ms. Mullen.
Okay, so then it's this, can we go down and see if this is the signed version then? Yeah, okay. So you did go up. Okay. Next page, please.
You mean the previous page? Which page?
Page down.
Okay.
Right top of there, sorry. So just at the top of that partial paragraph, does that say if the individual water right holder does not protest the authority's application, the authority will add the water right to special term meaning subordination? By adding these water rights to the special term, the authority will agree to subordinate its right to divert water.
Objection. The document speaks for itself, but it's still not clear how this is relevant to the rebuttal testimony.
Well, paragraph 11 talks about and its value of trust, integrity, and respect for local communities in the strategic plan. Does requiring a water right holder not to protest respect for local communities and integrity?
Mr. King, how does this relate to the agreement with Maxwell Irrigation District? Right, we're not talking about, as I understand it, we're not talking about Maxwell Irrigation District water rights.
No, we talked about the Maxwell Irrigation District. Well, there's two parts. One is just about the site's assertion that the strategic plan is for integrity and respect of local communities, and they actually demanded that we not protest if we want a subordination.
The
So I
other
don't-
the other piece of this, Mr. King, is I explicitly recall going through this on your cross-examination, probably of Ms. Forsyth in case in chief. So I don't want to cover the same ground again.
Fine, so then just if we can find the exhibit to this because it relates to an issue regarding the water rights and the conflict between with the conditions they're proposing. So
And does that, Mr. King, does that relate to, how does it relate to the testimony in paragraph 11? We're in rebuttal, so we're confined.
because she introduced the Maxwell Irrigation District and it has the 1995 water right application by Maxwell Irrigation District, and there's an overlap in diversion periods between that right and my rights, which have been given subordination.
So we're trying to understand the relationship between the sites authority, any right that the
Right.
sites authority may obtain, the right the Maxwell Irrigation District has, or at least this particular one, and then your.
Correct. And so I want to show the as a way of foundation, I want to show the priority date, the diversion dates under the three applications that the three permits that have not been subordinated.
Okay, we can do this, but we can't do it in the next 4 minutes, I think.
Well, I think if you can, if we find if you scroll, I think if you scroll up, it's the same because I don't think it has.
Final table is down below the signature.
Okay, then there it goes. Then we'll find it. They'll get done.
I'll give you 2 minutes.
Okay.
We can get to this in the morning, in Monday morning. It's not.
Well, I think this would be a good way. Okay, so just Miss Forsyth, do you see the diversion, the season start and season end for the three T&M King permits that are on this list? Do you see that it starts March 1?
I do see that, yes.
March 1, okay. And then also then September, we have the term 91, but also, so March 1 to 6:30 and then 9/1 to 10/31.
I do see that that's what the table says, yes.
Okay, so I think we can end there.
Okay, great. Thank you, Mr. King. We will pick up first.
Sorry for the, I misplaced it. I had open papers, I misplaced it. I apologize for taking time.
We found it. We will pick up there on Monday morning. In the next 2 minutes, I will look to the room. Are there any other procedural issues we should address before we break for our weekend?
Just if Mr. Hitchings has an idea of when he might get back to us on the issue we raised this morning.
For the Excel spreadsheet.
AHO sites 35. 335.
And hoping that we can send it out on Monday.
Thank you. Appreciate it very much.
Yeah. Thank you.
And thank you, Mr. Hitchings. Anything else? All right, well, we are adjourned. Enjoy your weekend, and I will see you on Monday morning at 9. Thank you.
Thank you.